case briefs, and so much more. LS Data's got what you're looking for.
In the 1955 case of National Labor Relations Board v. Business Machine and Office Appliance Mechanics Conference Board, Local 459, the United States Court of Appeals for the Second Circuit revolved around the idea that under the National Labor Relations Act, unions are generally prohibited from picketing secondary businesses or encouraging employees of those businesses to stop doing business with the primary company involved in a labor dispute. As a result of a labor dispute between the Royal Typewriter Company and Local 459 IUE-CIO, the union called the service personnel out on strike over negotiations for a new contract. During this time, workers picketed both Royal's customers and independent repair companies, which the National Labor Relations Board found to be unlawful. However, the court disagreed with the board's findings, citing a lack of substantial evidence that any of the employees of Royal's customers were unionized or affected by the pickets. Ultimately, the court ruled that Local 459 had not committed an unfair labor practice by picketing Royal's customers during the strike, as there was no evidence of unlawful inducement or encouragement of employees to cease business with Royal. The board's order was not enforced, as the court found it lacked substantial evidence to support its findings.
Case briefs, and so much more. LS Data's got what you're looking for. Visit lsc.law, elevate your mind. Leave the stress of class.